Hi, everybody. Thanks for tuning in. We appreciate it. Look at that smiling face over there. You'll recognize that as Craig Capilla, lawyer extraordinaire from Chicago. Craig, how are you this morning?
I am excellent, Tim. How are you doing today?
Great. Thank you very much. We appreciate you being here. I appreciate you being here. We've worked together in the past on various issues, and because you understand what's going on, because you look at this, you look at these legal issues we're going to cover differently than appraisers look at them. One of the reasons we're here this morning is to get your take on what's going on. Now, before we get started, legal disclaimer, yes, Craig's an attorney, but he's not your attorney, and he is not giving you legal advice. So please don't take it that way. And Craig, you're licensed in what, Illinois, Michigan, and Minnesota, or
So
Wisconsin?
I'm licensed in Illinois and Wisconsin and a handful of federal districts around kind of surrounding states also, and then the Seventh Circuit for purposes of, well, we hope we never get that far.
But for example, if you're in California or Texas or Nevada, Craig is not licensed in those states. So therefore, this is not legal advice. This is wisdom on Craig's part. So please don't interpret it any other way. Now, Craig, you and I have spent the last few minutes having an absolutely thoroughly wonderful conversation about blues guitar and a few other things, but we have to get serious. We're going to talk today about two major lawsuits that have affected appraisers. The first one is the older one, and that's Tate-Austin v. Miller. And then the second one is a little bit newer one, which is Connolly and Mott v. Lanham et al. So let's start out with Tate-Austin v. Miller and give us a little background on that. And then let's discuss the issue of the fact that it settled, therefore the case is no longer active. But in its settlement, it didn't answer a lot of questions. So starting out with Tate-Austin v. Miller, giving us the briefest of briefs, what was the complaint behind Tate-Austin v. Miller?
Certainly. Well, thanks, Tim. There's been a lot of activity really in both of these lawsuits, and as we'll discuss them today, there are some great similarities between them, but there are some differences as well. The Tate and Austin v. Miller matter is a lawsuit that was filed in the Northern District of California. It's in the San Francisco Bay Area, specifically in the North Bay area. And this involved a primary residence that was in an unincorporated area out there. It was in an unincorporated community. I'm assuming that most of the viewers, listeners are going to understand what that means, but in essence, it's not a municipal corporation. So we're talking about an area that's going to have shared services or possibly different amenities than the other local surrounding municipalities. So you've got a property that's located there. The homeowners had bought the property, had put extensive renovation into the property, and then were seeking a refinance. The appraiser came out, appraised the home. The number did not come back as they expected. They got a second appraisal. That second appraisal was nearly $500,000 higher than the first appraisal. And subsequent to all of that, the homeowners filed a lawsuit against the appraiser and against the appraisal management company that had ordered the appraisal. And so this is the case that's out in the Bay Area. We'll talk about the latter case as well with Connolly and Mott and Lanham. Although interestingly, this is a property in Baltimore, so we're back in the East Coast for this one. This is a property wherein there was a first appraisal, there was a second appraisal, and ultimately the property owners sued the appraisal management company and the appraiser. So already we've got some significant similarities between the way these cases track. The same sorts of parties are involved, and the thought process, the approach to the legal theory is largely the same. All right, taking us back out to California again. This initially started off with filings of motion to dismiss. So there was some wrangling about that. There was actually some limited success in the motion to dismiss brought by the appraiser in that case. It was a little bit of a Pyrrhic victory, however, and I know there's been some discussion about that, not enough, quite frankly. I mean, the day after that ruling, I was reading headlines in various appraisal and real estate publications. Appraiser gets case dismissed on discrimination. That was an extremely limited reading. It was merely the negligence component that was thrown out. The remaining claims were the various federal and state fair housing violations that were alleged in that matter. Well, ultimately, and now kind of speeding up to the end, ultimately back in the fall, the appraisal management company, the appraiser, and the plaintiffs sat down and had a settlement conference. Subsequent to that, the appraisal management company settled out the claim for what is a private and confidential settlement. We have no idea necessarily what the terms of that settlement are, and we're not likely to find out. That left the plaintiffs, their law firm, which is a consumer advocacy group, standing on one end, and the appraiser standing alone on the other end of this. And at a certain point in all of that, the United States had sought to intervene as an interested party as well. I think everybody knows at this point that the federal government via HUD and CFPB and various other actors, DOJ, are looking at bias and discrimination claims. So the government sought to intervene in that case as a statement of an interested party. We'll come back around to that idea in a minute. But anyway, so you've got a law firm that's a consumer advocacy group, you've got the plaintiffs themselves, you've got national media following it, you've got the United States of America intervening and saying, we're watching this very closely, and you've got an appraiser standing there alone at that point. What we have come to find out more recently, and I mean, as we're sitting here at the tail end of March of 2023, while we're recording this, within the last several weeks, we have come to find out that the appraiser ultimately did settle the claim as well. Again, it's a confidential settlement. We have no idea what any financial terms might be. We don't really know the particulars of what's going on there. I will say this, on the federal docket, you can follow that case online. By all of that is public record. There has not been an entry in that case since December of last year. So anything that's gone on with settlement discussions, additional settlement conference and all that, none of that's entered in there, nor is there any entry of a dismissal, a judgment, anything along those lines, at least as we sit here currently. So at some point that will be updated to reflect that the case is now closed and that everything is settled out, but we really don't have much in the way of information as to how that case settled, except for the plaintiffs and counsel have had additional communication through the media. And so some of the terms that have slipped out are the appraiser is going to be required to watch the documentary that came out late last year via, I want to say, ABC and Hulu, regarding whitewashing of properties and discrimination valuation. The appraiser is going to have to take additional fair housing training. But that's it. We don't know about any financials or anything else like that. So that's the extremely broad brush view of the California litigation, which is now concluded.
From a standpoint of, okay, all right, the federal stuff is over, the suit is settled, and while there may be some paperwork to handle, I think we can say it's effectively over. Now, let's look at it from a little bit more intimate view. I'm not aware of any problem the appraiser in Tate-Austin v. Miller is with the state of California, if any at all. I don't know. Do you know anything about that?
I don't. I'll put it this way. I have not heard anything along the lines of there being a companion case dealing with appraisal licensure. I've not seen anything about that. I will say in the cases that I work on, I do frequently see those cases be in parallel. Frequently a complaint will be turned in to HUD and also to the state licensing board at the same time, and different states will handle it differently. So I can't say with certainty that there is no licensing component to all of this, but I've not heard that there is. It may be California is a state that will hold and wait until the conclusion of any active and pending litigation before they take on the licensing component. I'll say apart from the bias and discrimination matters, because that wasn't really a thing when I was a prosecutor, at least not in the valuation space. We'd get fair housing claims and the like, but with appraisal complaints, if there was pending litigation against the appraiser, a lender on a loan buyback would file a negligence lawsuit against an appraiser and also send it into the state board for review and prosecution. Our posture at the state of Illinois, at least at the time, was we would hold the regulatory case in advance. We would put everything on ice because our role is not to be used as a bludgeon in the civil court system. If you want to go and fight over in the civil court system and have that out, you go right ahead and do that. We're not going to contribute to this in any way by coming up with a determination either that the appraiser was swell or, oh my goodness, look at these USPAP violations, because frankly, the wrong jurisdiction to have that question. Our decision as a regulator should not impact what goes on in a civil matter. You've got your own separate burden of proof. You've got your own elements of your claim you have to prove. Leave us out of it. We'll get back around to it whenever you wrap up what you're doing. I can't say for sure that's how California functions, and I actually can't say for sure that's exactly how Illinois does things today. I've been gone for a decade, but at least at the time, I know that was kind of our common thought process, and I do know that there are some other states that approach it that way. Conversely, I know of some other states that receive a companion complaint and they go, all right, this is a licensing complaint that's alleging discrimination, and you've also turned this into HUD or to the state functional equivalent to pursue a fair housing claim. Well, we looked at it and we can't find anything that looks like a USPAP violation, so we're closing this. Go sort the fair housing part out over there. And I do know a handful of states are approaching it that way as well. So again, unfortunately, like this entire regulatory system we have is inconsistent across states.
Yeah, yeah. A USPAP is neither uniform nor standard. Okay, let's back up. One more question on Tate-Austin v. Miller, then we'll get to Connolly and Mott v. Lanham. The case settled. Okay, that means that somebody, the insurance company or somebody, wrote a check to somebody else to make this whole thing go away. Now, one of the plaintiffs in Tate-Austin v. Miller was a fair housing law firm. Now, I hate to be cynical, so please forgive me. My true colors are coming out. But is it possible, is it within the realm of possibility that the plaintiffs in Tate-Austin v. Miller sued Mrs. Miller not because she did anything wrong, but because they thought they might get some money out of it to continue their crusade?
I mean, if I'm answering that bluntly, yes, it's absolutely possible. The reality of this, I think, is there's going to be multiple motivating factors for the parties that get involved here. I think since the outset of these discrimination and bias claims, I've been pretty steadfast in my belief, and I've at least been trying to express this. I genuinely do believe that most of the aggrieved parties truly believe that they have been discriminated against. I think there is wherein you and I would look at the valuation problem, and we would look at the approaches, we would look at the methodology, we would look at the analysis of the appraiser. The average consumer is not equipped to handle any version of a 1004 form, let alone the UAD. I mean, you want to tell me, well, what is it about my house that's different from that house three doors down? Well, the C4 of the Q2, nobody knows what we're talking about at that point. It was already a bad form to begin with, in that there is no such thing as a form that complies with USPAP, despite what form filling appraisers might believe. The appraiser complies with USPAP. No form can get you across the finish line. But even then, even in its earlier pre-UAD iteration, you've got appraisers that are writing a report for a sophisticated audience. The lender knows what the appraiser means, or we presume they do. Once we added an additional layer of coding on, it made it even more difficult for the average untrained consumer to understand what was going on in the appraisal report. And conveniently, since we did that, I believe it was late 2009, early 2010, that we rolled over into the UAD format. We did that and timed it conveniently with that other part of Dodd-Frank, where we now actually have to give the consumer a copy of every report. So we made it harder for them to understand. At the exact moment, we made it a legal requirement that we have to hand it to them. It's sort of been a mess ever since that moment. So it's a long, rambling answer to say, I think in any circumstance, the folks that are claiming to have been harmed here, I think most of them are genuinely of the belief that they have been discriminated against. And I can tell you from the cases that I've seen that circles around the difference of a C3 and a C4, and they don't know why one's a C3 and one's a C4. So if you want to get really into the UAD weeds for a second, I think every case I've had come across my desk has been circling around that particular issue, whether it's the subject itself or the selection of the comparable sales that are also of that C4 variety. Okay, so that's just something for everybody to keep a close eye on. If you're on the fence and you're not sure if it's a C3 or it's a C4, you'd better do a really good job writing up exactly why you've made the decision you have here. That goes a long way. Answer the question before somebody gets to ask that question of you. But now, Tim, to your original question here that I rambled on about, yes, you also have a plaintiff's firm that is a consumer advocacy group. First of all, I know this is shocking to people, but lawyers and law firms typically like to take on work that pays them. Okay, so that's always going to be a motivating factor in all of this. I am a defense attorney at this point. 99% of the work I do is in defense of claims. I also tend to counsel people through their approaches. When do you want to look for an off-ramp? How hard do you want to dig in and fight about this? Because one of the things that lawyers possess, especially litigators in our sphere, is we're always happy to fight to the last drop of your blood. Okay, that's from our end. You want to fight on principle alone? Well, that's your principles, and I'll let you fight for them. There is a motivator. I mean, we want to talk about biases. There's a bias I have, right? Clear as day. You're going to keep paying us to continue fighting for something for you. I might recommend against it, but you want to keep going? We're going to keep going. On the plaintiff side of things, your worth, your value as a plaintiff's attorney is getting wins and keeping the lights on. And so you're going to look for cases that you think you've got a plausible or colorable argument. I will tell you, when we're talking about both of these cases, the approach, the argument, the legal theory is eerily similar. So there was some thought that went into this. I would bet that there are some other potential bias or discrimination claims out there that were not picked up and were not pursued because they didn't look as meaty, as juicy, as potentially successful as these ones. And for that plaintiff's firm, you can bet, we don't know the financial terms, so we don't 100% have evidence to back this up, but you can reasonably infer they're getting paid something here. They're getting a cut of whatever comes across the wire. Now, how much was that? I don't know. We had two insurance policies playing ball here. We had the appraisal management company. We had the appraiser's policy. We likely had different limits of exposure for each because typically the larger operation will also typically have a larger potential outlay per claim and certainly as an overall cap. So you've got differing pots of gold at the end of that litigation rainbow that we're playing for, but it's a reason also in part why you name as many, as a plaintiff side attorney, you name as many parties as you can reasonably grab a hold of, because that's more policies at the end of this that might be avenues to recovering money. So yeah, it's absolutely possible and plausible that one of the calculations that went into this was what looks like it's going to have the most likelihood of success, what has the most colorable story that we can advance here under the legal theories we're going to try to pursue, and frankly, who looks recoverable. Hey, we've got some folks here that have active insurance plans that are going to cover them. They have a tower of coverage with them. You can be right as much as you want, and if the party you're pursuing doesn't have the ability to pay you, it doesn't get you very far either. So certainly all of that was a consideration in deciding whether to charge these claims and go forward.
Craig, you didn't ramble on, but I do appreciate the Led Zeppelin reference. Let's talk about Connolly and Mott v. Lanham. And you and I were talking before, and even though this is a totally separate case, and this was in Maryland versus California, we were talking about the uncanny similarities between the two of them. So can you brief us on Connolly Mott v. Lanham, or excuse me, Connolly and Mott v. Lanham?
Yes. So some differences, but some striking similarities between these cases as well. As we've mentioned, this is a case now, both are federal lawsuits. This one is now in the District of Maryland. So we are completely on the opposite side of the country, but similar fact pattern in the setup of all of this. We've got the homeowners, we've got the seeking a loan, we have an appraisal management company, we have an appraiser, we have a second appraisal, we have the whitewashing process again, and that leads to this lawsuit as well. So we've got plaintiffs suing appraisal management company and appraiser, just as we had in the California case. Walking down some of the paths of similarity here, the same sorts of issues about the appraisal are raised here. Specifically, this starts to focus on both cases. We're focusing on selection of comparable sales, the sales comparison approach, specifically the geographic selection of comparable sales. California case, unincorporated area. We talked about that briefly. Why aren't you pulling sales from Sausalito? Why aren't you pulling sales from Mill Valley? Well, because median sales price in Mill Valley is nearly double the median sales price in this unincorporated area. Things along those lines. Baltimore, same idea. We're in Maryland. We're in Baltimore, Maryland. We are in a historically Black neighborhood in Baltimore, Maryland. And now we're raising questions again about the selection of comparables and why did appraiser number one confine their sales search and select comparables only in this particular geographic space, whereas appraiser two went and found other sales from this area, and lo and behold, those are sales that elevated the opinion of value of the subject property. So really, as much as we've got a couple of appraisers here, we've got Miller in California, we've got Lanham in Maryland, and they're really taking the brunt of this. My overall view on this, what's really being put on trial in these cases is the valuation process itself, specifically the sales comparison approach, specifically the factors that are considered when deriving the most appropriate sales, when determining what is truly a comparable sale. When you're filtering your sales data down from, I have this age of a house, I have this room count, I have this GLA, I have whatever else it may be. The crux of these cases right now is really, where was the geographic ring? What was the boundary of the appropriate market segment? Where are we drawing appropriate sales from? Are they supposed to be confined and near the subject? Or why can't we go outside of those bounds and find other similar type properties? And unfortunately, because of the way lawsuits work, nobody gets to step right up to the podium and just answer that question. You've got the Austin Miller case, Austin Tate and Miller, that has settled. There's no depositions here. There's no other statements. We're never going to get the explanation of whether or not the selection of sales was appropriate or not. Right now, in the Connolly and Mott matter with Lanham, we're still in motion practice is what we call it. We've had complaints filed, we've had motions filed. We've done nothing substantive in this case yet. So we still don't know, and we may never know, was the approach taken by Lanham appropriate here or not? I'm always hesitant in these two appraisal cases where one of the appraisers is getting charged with wrongdoing, and we do have a significant differing of opinion in the ultimate value conclusion. Here's the part that I get stuck with, and we're not going to get any satisfaction. We're not going to get an answer out of the California case. It's too early to tell, but we may never get satisfaction out of the Maryland case. Here's the analysis that nobody's doing and may never do unless this goes all the way through the discovery process and goes to a trial. I need to see these two appraisals. I need to see these two appraisals that were done by two different appraisers. And I need to have them side by side. And we need to consider the standard 1 and standard 2 elements of both of these appraisals. We need to understand what the development process was, and then we need to understand how it was reported. Because here's the only thing I do know. When I have two appraisal reports, and I get this lands on my desk. I have two appraisal reports for the same subject property for arguably the same date of value or very near to. And I have a very large difference in the concluded value by the appraisers. Here's what I know. At least one of them has to be wrong. Here's what I don't know. Is either one of them right? Are they both wrong? Did they both miss the target going in opposite directions? Without being able to sit down, set them side by side, and truly analyze, one might suggest review them, say standard 3 and 4. Without that, I don't know that we'll ever know who was right or who was wrong. It's possible both appraisers missed the target. It is absolutely possible. The only thing we know for certain in this is that one of them had to. Nobody's asking whether the second one did. And I have, as a defense attorney, and one of my biases coming back into play here again, I have a problem with that because I'm typically the one that ends up having to try to defend the first one. Why is nobody asking the question of, why should we believe the second one? If we're doing this, if it's all about credibility, if this is where we're aiming, the point of all of this is to produce credible assignment results and a credible opinion of value. How do we know the second one's credible? And it might be here. We don't know that. I don't have a copy of the report. I don't know who has a copy of the report. Surely it would come out at some point in discovery. Maybe, or maybe not. Even in discovery, it's possible that all of the analysis, all of the workup is confined to both sides hiring competing experts to dissect the one appraisal report of the defendant appraiser. Well, we need to get a copy of the loan file and figure out what the underwriter did here. And we need to get a copy of that second appraisal. And there's an objection and they're going, no, we don't. It's not relevant to this case to determining whether or not this appraiser did it right. So the second appraisal may never go under the microscope. We won't know these things. Okay, again, I got off on a little bit of a tangent there, but that's one of the issues that we're dealing with in these cases. We've got two appraisals. The first appraiser is the one sitting in the hot seat, and the first appraiser is the one sitting on the hot seat on behalf of the entire profession, because it's actually the appraisal process that's being challenged by these allegations. The individuals are named, and they're being accused of performing faulty analysis. But at the end of the day, it's the methodology itself that's being questioned. What about location, location, location? Why are we giving that so much weight? Is this how we want to value properties? Is it appropriate to confine this to this area? And that's what we've got going on in both of these cases. Lanham takes a little bit of a different turn, though. Lanham punched back. As defendant, when they filed an answer, so this appraiser and counsel filed an answer and also a counterclaim wherein they allege that plaintiffs have defamed him, have gone on a media tour, have made statements, and as a result, they've caused harm, professional harm and personal harm, emotional distress, loss of business opportunities. So there's a quantifiable harm there. So unlike the California case, we actually have a cross complaint here where the defendant has fired back and taken a complaint against the plaintiffs as well for statements made outside of the courtroom. Just recently, and I'm talking about within the last 2 weeks, plaintiffs have filed a motion to dismiss the counterclaim. So that's just at the earliest phases here. We don't know where that's going to go yet, but Maryland and a number of other states have something called anti-SLAPP with 2 P's statute. And that is more or less when somebody is alleging defamatory statements, there is a chilling effect on people making statements. You say something mean, nasty, potentially incorrect about somebody, and you might have exposure to a defamation lawsuit, slander, libel, depending upon the method in which you communicated whatever you said about them. Anti-SLAPP is a statute that empowers a party who is defending a defamation claim to punch back again against the person making the claim, saying, hey, I made a public statement about you. I made a statement that was in bounds. Even if I turn out to be incorrect about that, the statement I made was appropriate and constitutionally protected. And the only thing that you're doing here by suing me is you're attempting to harass me and silence me and stifle my constitutional right to speak freely about this. So the motion to dismiss the counterclaim is based on Maryland's anti-SLAPP statute, which could entitle plaintiffs in this one, if they're successful and get the counterclaim dismissed and actually determine that there was a violation of the anti-SLAPP statute, there's actually a potential additional risk to the claimant in the defamation case for wrongly asserting a defamation claim. So it's interesting. There's now like 3 layers of the argument going on here. And we're not going to get any clarity on that anytime soon. That's all going to have to get sorted out over the next handful of months. There will be more briefs going back and forth on that. And then just last week, in this case, the United States of America filed a motion for leave to file a statement of interest in this case. So again, the government has looked at this case and is seeking to insert itself as a nominal party on the sidelines with an indication that it believes there is a significant harm, a significant risk due to a belief that there is widespread discrimination in the valuation space. And so it will seek to monitor and participate where appropriate in this case.
Craig, we could go on about this. I'm finding this absolutely fascinating. We could go on for quite a long time, but we do have a couple of time limits here. Let me address one more issue, the concept of the sales comparison approach. In Tate-Austin v. Miller, basically the complaint asked the judge to declare the sales comparison approach is wrong. Of course, now that that case has been settled, that question has not been answered, and indeed will never be answered. In looking at Connolly and Mott v. Lanham, the issue of the sales comparison approach comes up, but the plaintiffs do not specifically pray the court to declare it unconstitutional or illegal or fat and ugly or whatever it is. Is that because the question in Tate-Austin v. Miller was just not settled and therefore not worthy of raising? Or in this particular case, are Connolly and Mott trying to hide behind other charges the fact that they're praying the court to declare the sales comparison approach as discriminatory on its face and that's not allowable?
I think in this instance, the styling of the complaint in Connolly and Mott maybe approaches that question a little more subtly. There is a significant portion of the complaint, there is significant detail that focuses on the geographic boundaries of the sales that were analyzed by the appraiser. And so that's really the segment that goes towards approaching the fundamentals of the sales comparison approach and how the data is filtered and what's considered and how it's done. I do think they couch it differently. In the Lanham case, they actually identify a second appraisal for a different borrower, though it was performed substantially in the same manner. And again, I think the plaintiff's argument is, see, that's proof, and they actually even style it. It's a pattern of practice of this conduct. And from the defense end of things, I won't speak for the defense counsel in Lanham and how they're going to do things, but I would view a similar type charge in a case where I'm defending an appraiser as, oh my goodness, yes, you found 2, perhaps 3, who knows how many appraisals wherein the appraiser did things exactly the same way. That's because they followed appropriate and understood methodology. And that's how they always do this. Coincidentally, what you'll find with a lot of the regulatory complaints, matters that are getting turned into HUD as a fair housing claim and the like, one of the things that is frequently sought after in the investigation process is additional appraisals, not specifically the one in question, but other appraisals for the same client or other appraisers, other appraisals in the same geographic bound, whether it's a particular community, a neighborhood, whatever it might be. And they say, okay, we need to see some more of these. And so I do think that's the analysis that's going on the back end here is, did you treat these particular borrowers different than anyone else, or are there similarities? If you want to be cynical about it, you're looking for a pattern of practice. Do you have a habit of treating borrowers this way? A less cynical view of that would be, do you always approach the assignment the same way? And that's really the argument that I think is going on here.
Okay, you didn't want to answer, or you didn't want to respond for the defense, which makes sense. So, but if an appraiser did want you to respond for their defense, how would they get a hold of you?
So there's a couple of different ways to get a hold of me. We're a resource. So if anybody has any questions or any concerns or anything, we're here for that. We're a resource. We're a sounding board. We're always happy to help. I'm a partner in the firm of Franklin, Greenswag, Channon, and Capilla. And as I like to remind people, Franklin, Greenswag, Channon, and Capilla, I'm the last one you think of. I have email here. It's my first initial and last name. So it's CCAPILLA@fgcclaw.com. And I'm available by phone as well. Area code 847-701-2250. Or if you just go to fgcclaw.com, you can find all that information on there. And we're around. We're here to help. We're here to get people pointed in the right direction, even for the sorts of stuff that we can't handle ourselves because of our geographic bounds and our permissions, our licensure. Anytime we can assist and get people pointed in the right direction, we're always happy to do so.
So when you get that letter from the state board and you need to chilla, call Capilla, right?
I love that line, by the way. That was great. I saw that.
All right, Craig, thank you. I appreciate it. It's always good to be with you. I appreciate your candor. I appreciate the depth of your knowledge on this stuff, and I appreciate what you do for all real estate appraisers. Now, we're recording this at the end of March 2023. So if you're watching it after that, this won't be timely. But Craig, you will be in Sacramento at ACTS, will you not?
I will be. So I will hopefully be catching up with you in several weeks' time at the ACTS conference in Sacramento. That's the next stop off for me. I just got back recently from hanging out with my dear friends at SCPAC in South Carolina. Love them dearly. I will be in Sacramento for ACTS. Thereafter, I will be headed to Savannah for Aero in May. And that's about as far out as I can think right now. That's I got enough other stuff on the plate. I barely know what I'm doing tomorrow. So
Yeah, I completely understand. Totally. Oh, and you remember that you have a wife and children somewhere in the background, someplace.
Yeah. If anybody ever needs a good lawyer, I'm married to a great one, so I can help you find one.
Oh, all right, good. It's good that you get to see them on occasion. All right. Well, Craig, again, thank you. I appreciate it very much. And this will, if you need to talk to Craig, you've got his email address, you've got his phone number. He will be at ACTS, he will be at the Aero conference, and you'll also find that he's also a gentleman and a heck of a nice guy. So
that's defamatory, and depending upon your state laws, there may be actionable.
Well, I could be wrong. It'd be the first time in the last 3 seconds, but yeah, I could be wrong. So, Craig, again, I thank you. And everybody, thank you. We appreciate you listening, and we'll be in touch. Thanks. Bye-bye.